Thanks, Sam, and welcome to the presentation today, amendments to the UCC Article 9. For those of you who have been doing this for a while, this is not like the last go-around of UCC changes. This is a smaller chunk of changes for everyone to digest. Hopefully we will all remember not to kill the messenger here today. I mean, these are the legal changes, but obviously the effective and operational changes we're all going to suffer together go beyond the what I'd refer to as generally minimal changes to the UCC itself. As we get questions, I'm sure a lot of stuff we will need to kind of distinguish is when we're dealing with headaches and problems we'll run into on the operations and tracking side of things. Because again, at least for the most part, conceptualizing the actual changes to the Uniform Commercial Code are not particularly difficult. Today's presentation is based on the suggested amendments to the Uniform Commercial Code, that's been enacted in all 50 states. As of today, I believe 39 of the 50 states have adopted the changes, and we have a couple different routes people could have taken in adopting those changes that will cover both areas. It's important to know, even if some of these changes that we deal with weren't enacted in your state, you may be dealing with a debtor in another state, and in that case, the law of that state may govern. So it's important to not just tune out when one of the options we're talking about doesn't apply to us. As Sam mentioned, we should have ample time for questions. Unfortunately, like most presentations, I won't have a lot of experiences to draw on in dealing with these changes since they are new. Some of the questions that we get will probably inevitably lead to my best guesstimate on how things may or should be handled. So feel free to disagree with me in some of those cases internally, as my suggestions or thoughts may not fit your institution and how you handle things on a day-to-day basis, especially with regards to some of the issues we're talking about today. So after that kind of long-winded introduction, let's go ahead and get started with the presentation. Basically, our new changes are going to become effective July 1st, 2013 in most states. It's important for everybody to figure out what the effective date for your state is. I sit on one side of the state line on Kansas. I believe we're effective July 1st. And then on the Missouri side, we're not effective till, I believe, July 28th of 2013. We're operating under the assumption that those changes, since they have been enacted, we're just kind of operating as if they're already effective. There's really no harm in that. So we're going to go over the changes, and then we're also going to review changes to some of the UCC form financing statements. There's nothing too crazy there, a few tweaks, but then also talk about some of the ways we can utilize the forms and generally to help accommodate some of the concerns that may arise. Our new changes are referred to as the 2010 official amendments because the American Law Institute and Uniform Law Commission actually adopted them back in and finalized them back in 2010, but recommended adoption by the states not until this year, 2013. So they are referred to commonly as the 2010 official amendments, even though obviously we're not dealing with them until now. So the primary drivers for these changes is that some of the states we're in adopted kind of non-uniform provisions regarding the sufficiency of a debtor's name on a financing statement, and more specifically, some states have had court rulings that were not in line with what the drafters had intended, and so some of the ideas behind making this uniform is to give us some certainty as to what names we need to be using. And in many cases, many state filing offices also had recommended various changes to the UCC 1 and other forms for ease of use and in allowing for a better notice of information where possible. So to date, I believe the following states have adopted the new changes already. I'll run through these quickly here before going on to the next slide. I believe we have Arkansas, Colorado, Connecticut, District of Columbia, Florida, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maryland, Michigan, Minnesota, Mississippi, Montana, Nebraska, Nevada, New Hampshire, New Mexico, North Carolina, North Dakota, Ohio, Oregon, Puerto Rico, Rhode Island, South Dakota, Tennessee, Texas, Utah, Virginia, Washington, West Virginia, Wisconsin, and Wyoming. I believe Delaware also recently, Missouri also recently have passed these. Kind of the states that have introduced legislation. I believe Oklahoma recently also passed. Some of the states that have introduced legislation but to my knowledge have not passed them yet are California, Georgia, Massachusetts, Pennsylvania, South Carolina, and Vermont. For those of you in New York, we're not quite sure what you're up to yet, I don't believe, and I don't know if legislation has or has not been introduced yet. We assume New York will fall in line with adopting the amendments, but at last check, I don't know that they had yet. To check and see where folks are with regards to enacting or either legislation or passing legislation, you can go to www.uniformlaws.org, and there will be a link to the Article 9 amendments for 2010. You can check on that to see where your state is with respect to having enacted legislation, passed legislation, and in most cases I believe it'll give you the effective date for your state. Again, it's www.uniformlaws.org. So the primary driver for these changes is dealing with the sufficiency of the debtor's name on a financing statement. The most significant change involves the method for determining what is sufficient for purposes of the UCC 1 financing statement. As we all know, individuals may use different variations of their name. People we've relied on at various times, birth certificates, Social Security cards, driver's licenses, passports, and other official type documents for determining what is the individual's name. So the Uniform Law Commission has attempted to give us some guidance here as to what all states should do so that we can be consistent in application. But as you see, we still have some loops that we'll need to deal with and holes in our law that we'll need to deal with. As we also know, corporate entities must use or may use a trade name or a DBA, so we're also going to talk about what's the proper name for purposes of filing UCC 1 for that corporation. We have some additional guidance on that. It's fairly straightforward, but it may cause us to need to jump through an extra hoop, but should give us some certainty when identifying the legal name for a corporate entity. So it's important to remember that our financing statements are only sufficient if it provides the name of the debtor. If the debtor's name is not sufficient, the financing statement is not effective. So in that case, we, the creditor, would not be perfected in our collateral. It would allow another creditor to step in front of us and take our position with regard to the collateral we thought we had. So when dealing with an individual's name, the 2010 official amendments permit each state to choose between two alternatives for determining the sufficiency of a debtor's name on the financing statement. Alternative A, the only if alternative, provides a single exclusive method for determining the debtor's name. Alternative B, the safe harbor alternative, provides three non-exclusive methods for determining the debtor's name. Most states have adopted Alternative A. The only states, to my knowledge, that have adopted Alternative B are Colorado, Connecticut, New Hampshire, Oregon, and Washington. In an attempt, I guess, to be more progressive than the rest of us, wanted to present more options for folks. But anybody who's looked into this may have discovered that Alternative B could potentially cause us extra work and extra headache.